first speaker for this final session is Chris Green, walking up onto the stage here. Chris is an Associate Tax Director at Deloitte. He also leads the Deloitte School of Tax. Chris has a BCom, an LLB, postgraduate diploma in accounting. He's a CA and also has a master's in taxation. Chris has been with Deloitte for approximately 12 years. Has been involved with accounting and tax training at various levels over several years. Chris is also involved in the Deloitte Tax Technical Learning Function, which he has been involved in since 2006, and coordinates and presents technical and non-technical training to Deloitte tax staff and clients. Today, Chris will be talking to us on the transitional provisions, so without further ado, over to him.
Thanks, Carl, and afternoon, everyone. I think we've heard a lot of theory this morning around taxpayer rights, and I'm hoping in this session on transitional provisions, really to dive into a little bit more practical detail, I hope. So the title of the session, Transitional Provisions, might be a little misleading. We're certainly not going to go through all of the transitional provisions in the Tax Administration Act this afternoon. What I've tried to do is to pull out some selected areas that I think are of practical relevance, and more specifically, to examine whether the imposition of the understatement penalty retrospectively is something that we can do anything about. Okay, so with that in mind, I have kicked off with some fairly simplistic, sort of frequently asked type questions around the transitional provisions. And these were the kinds of phone calls I was getting last year in October from my clients. And it's always useful just to quickly skim through these, just to refresh our memories on the transitional provisions. So the first question there, what happens to my tax number? Very simply, in terms of Section 258 of the Tax Administration Act, we're told that tax numbers that were in force and effect before the Act became effective remain the tax numbers after the Act was implemented. Then with regards to the tax ombud, we've spoken about the tax ombud in some detail this morning. The transitional provisions specifically state that that ombud needs to be appointed within 1 year of the commencement of the Act. Like Beric mentioned earlier today, by 30 September this year, we should see the tax ombud. Okay, then the rules around the impact on the public officer. So Section 261 there states that public officers that were appointed before the commencement of the Tax Administration Act are deemed to be appointed after the commencement, so nothing that happens there to the public officer. Importantly, with regards to the rules for dispute resolution, we've also touched on that in the session before mine. The rules that were in place in terms of Section 107A of the Income Tax Act, although that section has been repealed, are still in force and effect until such time as the new rules, those draft rules that we spoke about a little bit earlier, that have come out in terms of Section 103, until those rules come into effect, we're still bound by the rules in terms of 107 Cap A. And then the last point, before we get into the meat, the impact on the Tax Administration Act in terms of rulings and opinions. Same principles there in terms of 269 subsection 3. Rulings and opinions that were in force and effect before the Tax Administration Act remain in force and effect provided relevant and consistent with the Tax Administration Act. Okay, so those are very basic sort of frequently asked type questions that you may have heard from your clients or had to deal with in your businesses. Here's the crux of my discussion this afternoon. When we get into Section 270, we start to look at language in the Act that deals with what the Act will do in terms of things that have happened in the past. And Section 270, subsection 1, kicks off how this will work, and it commences with the phrase subject to this chapter. So subject to Chapter 20, this Act will apply to any act, omission, or proceeding that was taken, occurred, or instituted before commencement of the Act. So it tells us up front, the Act will apply to things that happened in the past. But it then says, without prejudice to that action taken or proceeding conducted. So in the example of the understatement penalty, let's assume we have an omission that occurred before the commencement of the Act. Subsection 271 says the Tax Administration Act can apply to that omission that occurred before it came into effect, but without prejudice to the action taken. So for example, a tax return submitted that included an omission would be an omission that happened before the Act came into play, but the Tax Administration Act may apply to it. Right, so let's just park that issue for a second and dive down into Section 270, subsection 6. And this is the practical area that we're seeing in our practice at Deloitte. This section says that additional taxes, penalties, or interest, which but for the repeal of the old section, could have been imposed in terms of that old section, maybe, and it says imposed or levied in terms of the now repealed section, and then assessed or recovered in terms of the Tax Administration Act. Okay, so let's look at some of the practical issues that we're facing with this section at the moment. All right, so the main one I've mentioned is that SARS are now seeking to impose an understatement penalty in terms of Section 222 of the Tax Administration Act to tax periods that ended prior to the Tax Administration Act commencing. Okay, so for example, we had a case last year where SARS informed us that a letter of audit findings had been withdrawn to be reissued after the Tax Administration Act became effective on the basis that they would then be looking to levy the new Section 222 understatement penalty in terms of, instead of the Section 76 penalty that's now repealed in terms of the Income Tax Act. What's the impact on that to you as a taxpayer? So, whereas before, you were into Section 76 where there was intent, there was the 200% penalty that was levied, but there needed to be intent. You're now subject to a penalty regime that has got a sliding scale based on your behavior, but is incredibly difficult to come out of in terms of remittance. So you've had a penalty imposed upon you for a tax period where a different penalty regime was in play. Now that seems fundamentally inequitable. As Beric mentioned a little bit earlier, if we take the case of substantial understatement on that Section 222 understatement penalty, to get out of that substantial understatement, you needed to have the tax opinion drawn up in the year in which that tax return, where your position was taken, was filed. Now, how is it possible for a taxpayer to know back then that that was something that he needed to do? Okay, so it seems, on the face of it, inequitable. Okay, we'll come to possible remedies and construction of arguments in a second here, but just in terms of another practical issue, just looking at the wording of Section 270, subsection 6, if you look at the wording there, it says it may be imposed or levied in terms of the repealed section. Okay, so let's say imposed or levied in terms of Section 76 for an income tax return that was submitted, 200% penalty, but then assessed or recovered in terms of the Tax Administration Act. Now, on that wording, it's not entirely clear to me that imposed or levied includes the word remitted. That word isn't there. Is it to be read into imposed or levied, which might make sense, or is it to be read into assessed or recovered in terms of the Tax Administration Act? If you look at the Tax Administration Act, the word assessment means to determine your tax liability, and the word tax in the Tax Administration Act is defined to include penalty. So there's possible argument, it seems, that the construction on reading this section of 270 would be that you impose or levy in terms of Section 76, but then you go and decide on remittance in terms of the Tax Administration Act, and you're right back where you started. You're under the restricted remittance requirements. I'm not sure if that's the correct reading, but it seems like you may be able to read it that way. Don't think that's the crux of the issue, though. The question here, and what I hope you can walk away with from this session, is when you're in this scenario now, in your business or with a client, is there some form of remedy or argument that you can construct when SARS have tried to impose this understatement penalty to tax periods that ended prior to the Act commencing? And to look at that, we're looking at this presumption that a statute doesn't apply retrospectively. What does retrospective application mean? It means that something's been taken away from you, so a vested right has been taken away, a new obligation has been created, a new duty imposed, or there's been an attachment of a new disability that relates to something in the past, so to a past event. That's retrospective application. So to look at the potential remedy that we might be able to construct an argument around here, what I've done is I've looked at those three sets or performed some analysis on those three areas. We've got the Constitution, the common law presumptions around statute interpretation, and the Interpretation Act itself. So let's dive into the Constitution. And we spent a lot of time on this today, but I'll re-emphasize what Beric said a little bit earlier. There's nothing specifically in the Constitution that says that a tax amendment can't be introduced with retrospective effect. However, if we start at the top of our Constitution, the founding provisions or the founding values include the supremacy of the Constitution and something called the rule of law. That's in Section 1C of the Constitution. You then move on to Section 2 that says, as the supreme law of our country, anything or any law or conduct that is inconsistent with the Constitution is invalid. So in other words, if it's inconsistent with the rule of law, it's invalid. Section 2 of the Constitution. Now, the principle of this rule of law, or one of the principles of the rule of law, is that a taxpayer or a person is entitled to regularize their affairs in accordance essentially with the law as it stands at a point in time. It's phrased there a little bit more technically, so you should be able to regularize your affairs on the basis that you can perform an action not prohibited by a law of general application. That's a principle of the rule of law, which is in our founding provision of the Constitution. So let's work through the following analysis. We'll kick off with working through 1C, the rule of law, which is found in our founding provisions. Then we'll take a look at Section 25 and 33, which are sections in our Bill of Rights, and Section 36, the limitation of rights. Again, we've touched on a lot of these areas in the course of this morning, but we're specifically considering them now with regards to the imposition of an understatement penalty retrospectively. Okay, the rule of law, in the court case, the United Democratic Movement had this to say about it. So it says, these founding values have an important place in our Constitution. They inform the interpretation of the Constitution and other law, and they set positive standards with which all law must comply in order to be valid. If we have a look at, I've pulled out two cases that I think will be interesting, and again, I think in the back of your minds, start thinking about using this kind of argument or response when this penalty has been imposed retrospectively. So the Anglo Platinum Management Services case held that the rule against retrospectivity is something that's firmly entrenched in our administrative law. So it's there. And it's founded upon this principle of what they call legal certainty, which in turn is founded upon the rule of law. Okay, so the legal certainty, you should be able to regularize your affairs in accordance with the law as it stands, and that is derived in turn from the rule of law, which we said sits right up at top on the Constitution. So the court held there that where the exercise of powers affects the rights and all legitimate expectations, retrospectivity is something that fundamentally undermines the constitutional principle of the rule of law. Okay, so there's case law to support that view. In that case, they also referred to the constitutional court case of the Pharmaceutical Manufacturers Association. Now, the court there endorsed that view in the first bullet, that the rule of law embraces some internal qualities of all public law, and these are key areas now, that it's certain, that it's ascertainable in advance, that it's predictable, and that it's not retrospective in operation. Those are key principles that have been endorsed by the Constitutional Court. The court there in that case also looked at what's called the doctrine of legality, that's been mentioned this morning as well. Essentially that talks to when you act outside the powers that have been conferred on you by law, the action itself is unlawful and unconstitutional in this case with the Pharmaceutical Manufacturers Association. So we're starting to build an argument that you could use in providing a response back to SARS in the instance where the Section 222 understatement penalty has been imposed for prior periods in terms of the presumption against retrospectivity. Interestingly enough here, if you that last bullet, and we've spoken about Section 36 and the limitation of rights, that limitation applies to the Bill of Rights. Now, the rule of law is included in the founding provisions of the Constitution, so sections 1 to 7 of the Constitution, or 1 to 6, and sections 7 to 39, which include the property and right to administrative justice sections, are in the Bill of Rights. So the rule of law is not limited in terms of Section 36. Okay, I won't spend too much time on the other two areas of the Constitution. So Section 25 and property, Judge Davis a little bit earlier this morning mentioned that he thought there was scope to look at making use of this section in terms of retrospectivity. The issue here is, in our case, where a penalty has been imposed, is are we dealing with a deprivation of property or not? I'm not quite sure that we are, but nonetheless, it's a section that one could consider in constructing an argument here. Assuming that we could get into an argument that the right to expect to have a penalty imposed in accordance with the law as it stood at a point in time existed, we might still be getting into the limitation in terms of Section 36. And that's because of the fact that the Tax Administration Act is a law of general application, which is a requirement in the limitation rights section, and provided that it can be shown that the limitation of that right is reasonable and justifiable, it's possible to happen. Okay, so we might consider using that argument. I think more likely is to get into the Section 33 and the just administrative action. Again, something that Judge Davis covered quite extensively in his talk to us this morning. And I think the crux here is that you've got administrative action. The one question I had is whether or not the decision to impose, or the imposition of a penalty where there's no decision, so it happens automatically, would fall into administrative action or not. That's not quite clear to me, but if you look at Section 270, subsection 6, it seems that SARS there need to make a decision because it says penalty may be imposed in terms of a repealed section. So there's a decision that's made, that's administrative action, and you could potentially challenge that in terms of Section 33. Okay, and just to remind, I don't think we've seen the text of Section 36 at all this morning or today. There it is for you just to have a quick look at. So it says the rights in the Bill of Rights may be limited only in terms of law of general application, so law that applies to everyone, to the extent that the limitation is reasonable and justifiable. Okay, so if we're taking a challenge in terms of Section 25 or Section 33 of the Constitution, it's possible that Section 36 would come into play. Okay, so that's the constitutional side of things. And really that is our supreme law, and that is where we go to look at whether we can challenge the administrative action in this case. However, we've got a very well-developed set of common law presumptions. Now, the question is, where do these common law presumptions fit into any kind of argument that we're going to construct? And my understanding of where we are right now in South Africa is that to the extent that these presumptions coincide with the Constitution takes precedent. It sits up above them. But those presumptions are still there to augment and enrich our Constitution. So it's worth just understanding or having some background on those in terms of the need to go and construct some kind of argument here. So the basic common law presumption is that there's a presumption against a statute applying retrospectively. That's a fundamental common law presumption. It's found wide recognition in our case law, both for statutory interpretation as well as constitutional interpretation. I've quoted there from S versus Mhlungu, where the Constitutional Court recognized the relevance of this presumption for constitutional interpretation. So the National Director of Public Prosecutions case also then recognized this principle of legal certainty. So in our common law, we find the same principle that's enshrined in our Constitution in terms of the rule of law, that a taxpayer is entitled to regularize his affairs in accordance with the law as it stands in a point in time. Essentially seen in the National Director of Public Prosecutions case in our common law. Importantly though, the common law presumptions, or our common law, states that this presumption against something operating retrospectively can be rebutted. Once it is rebutted, the effect is that provision is then to be construed rather restrictively, but there are instances where it can be rebutted. And I think it's important just to quickly have a look through those instances. So those are the 5 of them over there. And the first one really is the crux, I think. The common law presumption against retrospectivity is rebutted where the retrospective operation of a statute is provided for, either expressly or implicitly. So that's the first presumption. The second is where that statute confirms existing law. The third, where it confirms some form of doubt that existed around statute. fourth, where it relates to procedural matters, and then the fifth, where it operates retrospectively to confer some kind of benefit to the subjects, which makes sense. So you're being granted something that's beneficial to you, that's fine. Okay, I'd like to focus really on A and perhaps very quickly on D. So despite the fact that the common law says it's fine for a statute to operate retrospectively if it's expressly said to do so, the court has still held that in the absence of a contrary intention appearing from the statute, that retrospective application would not apply to completed transactions. And I think that's a very important principle. The courts have also held that that presumption is strongest in relation to legislation that imposes obligations or penalties. And then the final piece of common law around this Part A is, again in the National Iranian tanker case, that statute isn't interpreted as having retrospective effect unless that result is unavoidable from the language that's used. Okay, and I'm going to bring all of these principles back to an analysis of the imposition of the penalty in a second. So let's have a look at some of the key questions, if we've looked through those principles of the common law, that we might apply to the imposition of this penalty. So the first would be, is the retrospective operation of the Section 222 understatement penalty provided for? So either expressly or by necessary implication. I'm not sure that it is. If we look at the language in Section 271 and in Section 270 subsection 6, it says that the Tax Administration Act may apply to past events, but without prejudice to those past events. So possibly we're into that first question and we can say perhaps it is. The second question then would be, is there clear intent from the statute that the Section 222 understatement penalty must be applied to tax periods prior to the commencement of the Tax Administration Act? Again, I don't think there is. The fact that Section 270 subsection 1 says that it applies to past events but without prejudice to those events, firstly backs up that I don't think the intent is that that's the case. And the second in Section 270 subsection 6 that says you may impose in terms of a repealed section clearly states or clearly gives you the idea behind the intent being that you've got an option here. Okay, it doesn't have to apply retrospectively. And finally, is the retrospective application an unavoidable result due to the language used in those sections? And what I've just said now with regards to Section 270, subsection 1 and 6 would be repeated here in terms of that. I don't think it's a clear result from the language that you have to apply the Section 222 understatement penalty to periods that ended prior to commencement of the Act. Okay, so that would be a work through the common law principles. Of course, those sit underneath the Constitution, but they're still giving you the same answer here, that we've got a problem. With regards to that last point I wanted to discuss in terms of where the common law says that legislation can't apply retrospectively, or can apply retrospectively at least, it says when it deals with procedural matters. Now, in other words, where acts have been committed or transactions concluded prior to the commencement of a statutorily prescribed new procedure, should you subsequently go and bring suit after commencement of the new procedure, that new procedure will apply. Now, I think what we're dealing with here is not a procedural matter. It's a substantive issue. It's the imposition of a penalty. So I'm not sure that the procedural matter would come into our interpretation of retrospectivity. And finally, just to wrap up that third leg, so I said we'd look at the Constitution, we'd look at the common law presumptions, and then finally we'd look at the Interpretation Act. And Section 12 talks to the effect of a repeal of law. I'm not going to go through every single section of Section 12, but essentially it reads, where a law repeals any other law, then unless the contrary intention appears, the repeal shall not revive anything not in force or existing at the time at which the repeal takes effect, effect any right, privilege, or obligation or liability acquired under any law so repealed, affect any penalty, forfeiture, or punishment incurred in respect of any offence committed against any law so repealed, affect any investigation or legal proceeding or remedy in respect of any such right, privilege, etc. And any such investigation, legal proceedings, or remedy may be instituted, continued, or enforced, and any such penalty, forfeiture, or punishment may be imposed as if the repealing law had not been passed. So I I think in conclusion then, in terms of an analysis of those three areas, if we go right back to where we started on the Constitution, it's clear that the rule against retrospectivity is a principle of our rule of law. That rule of law is in our founding provisions of the Constitution. We've got a view from the Constitutional Court that supports this rule of law, and that law should be certain, it should be predictable, it should be ascertainable in advance, and it shouldn't operate retrospectively. Our common law presumptions working through them seem to support that view, and to my mind, there's definitely a strong argument that one could put together here, where you're faced with the imposition of this understatement penalty in terms of the Tax Administration Act to tax periods that ended prior to the Tax Administration Act commencing. Okay, that's what I've got in terms of the analysis. What I'd like to do now, Carl, if we could, is open the floor up to any questions or instances where you might have experienced this penalty being imposed, and perhaps share with us your experience in managing that issue. Down here in front first, if we could. Okay, we'll come to you next.
What we have currently is that we have a matter in PAYE, and it dates back to 2000. Of course, there's no trace of correspondence whether SARS issued it to us or not. And they are saying that they are going to recover in terms of Section 171 of the TAA. And so we kind of like in a corner. And we were thinking of maybe entering into a settlement. Can they actually do that, apply Section 171 in issues that have actually prescribed?
So that's a slightly different concept. We're talking about retrospectivity. Your question is around whether the prescription applies to this instance or not. And are they arguing, in terms of the prescription rules, is it an income tax issue? Are they arguing that there was fraud, misrepresentation, or non-material disclosure? I'm not sure if they're entitled to do that, but the principle on assessment would be that if they're raising an additional assessment, they'd need to do so by extending the prescription period for one of those three reasons. That would be my understanding. So I'm not quite sure how an additional assessment that leads to the debt not recovered could have a legal basis if that period is prescribed without one of those three instances. Down here.
We're having issues with deemed dividends of amounts prior to the imposition, or have to be prior to the imposition if it was STC, where penalties are being imposed, whereas under the previous legislation there wouldn't have been a penalty imposed for a deemed dividend not being disclosed. It would have only been the amount of the STC and the interest. So it's a slightly different position to what you've covered, where it wasn't covered before and now is covered, as opposed to it was covered on a different basis.
Is that with regards to a transfer pricing adjustment?
No, just a straight debit loan account deemed dividend.
Okay. The issue there, and I haven't looked at the deemed dividend one, but I've had a look at a transfer pricing adjustment where, and it might be a similar argument, but the onus was on SARS in prior tax periods to make the adjustment for transfer pricing, for example. And subsequent to the new transfer pricing amendments, that onus is now on the taxpayer. And the issue that we argued there was, where does the onus lie? Do you have an omission from a return where you've disclosed sufficient information for SARS to make that determination? But in the instance of a deemed dividend, I'm trying to recall if the onus was on the taxpayer or on SARS to make that adjustment.
article assets.
Yeah, so I think,
in each other. And the 64C is, in my view, just an extension of 64B. So whatever applies to 64B will automatically apply to any sort of obligation in terms of 64C. It's a difficult thing, that one. Very few people understand it. And SARS is also, as we all know, only waking up to deemed dividends recently.
yeah, so I think, I mean, the question there might turn on, to get into the understatement penalty. Understatement is a defined term, and in this instance, there need to be an omission from a return. And if I understand the technical position correctly, I'm not sure on it, but if the onus was on you to include that deemed dividend in your return, there's an omission from a return.
I understand that that would be the case. The issue, though, is had SARS come 4 months earlier and raised their assessment 4 months earlier, we would be liable for the capital. That's not an issue in dispute. The issue is we wouldn't have been liable for a penalty. Having come 4 months later, now we're in the new Act.
Okay.
We're now liable for a penalty, which is something that wasn't available to SARS to impose previously.
Okay, sorry, I misunderstood the question. So I think then you're squarely into what we've just discussed, because in that instance, you're now being penalised for a tax period that ended prior to the commencement of the Tax Administration Act, and you're squarely into retrospectivity here. So I think what we've just discussed would apply to that imposition of the understatement penalty. Yep.
Switch it on.
So
Sorry,
won't you turn your
I think it's
mic on? I think it's off.
I think the microphone's off here.
Can you hear me?
Yep, there we go.
Clients assessed capital with 10% penalty. 2 months before the new Act, he gets a letter from SARS, they're withdrawing the assessment, pending the new Act. After the new Act is issued, he gets the same assessment back with 100 or 250% penalty. We spoke to SARS. The attorney went and saw SARS, very, very hard-asked, not prepared to talk to them. Took High Court review, and SARS backed down.
Yeah.
So he's now back in a 10% penalty base.
Okay, and I mean, that's a nice example. And I think, I certainly felt, to a degree, quite intimidated this morning when we get the likes of Judge Davis and Berwick and the guys that are so well versed in administrative law. But how does one practically manage these issues? And I think you have to take them on. If you think you're correct, and often it's the research around the position you want to take. But there's plenty out there to build an argument around, in these instances, why what SARS are doing is incorrect. But it's nice to hear that there was a success story there.
Are there any other questions from the audience at this stage? Derek?
Well, I mean, the interesting question, and maybe Carl, if I could share the one that Carl posed to me a little bit earlier, is... is it...
I said I may be flippant, but isn't a lot of this conduct being driven by the incentives financially that is paid to SARS officials?
So I'm going to dodge that question, but but for me the interesting thing here is, in this specific instance, is this something that is policy of SARS? And this is a question that Carl raised with me. He said, are we talking about a policy decision, or is this an instance of people doing something because they don't know any better? It's not clear. I don't know the answer to that question, and I think it's a really good question. Is it SARS policy that they will levy the Section 222 understatement penalty as a matter of course, or is it something that's happening in patches because people are not reading retrospectivity into Section 270?
Well, Katinka, I don't know if you'll be prepared to take that question. You don't feel obliged to if you don't want to, but seeing as you are, we may as well take advantage. So we can just get a mic to Katinka.
Thanks, Kyle. I'll give you, as I said, the legal view. That's not necessarily the SARS view. But just on the application or the imposition of the law regarding understatement penalties, you hopefully read what the Minister announced in the budget review that we are reviewing, and there will be substantial changes to the whole regime, essentially to ensure that you don't capture taxpayers that made bona fide errors, like calculation errors, mistakes, etc., in the understatement penalty regime. Although that is essentially an understatement, it's not necessarily one that you need to sanction. So those kind of changes will be effected this year in the Amendment Act. Yes, I fully agree. The law says it must be a discretion that must be applied as to what behavior is applicable. And I do not know of any computer system that can actually do that or determine when is a fraud or when is a gross negligence. But those issues are under review. Just on retrospectivity, I mean, it's sort of strange because I think the additional tax regime was much harsher to a degree, 0 to 200% than the new understatement penalty, or that was actually the intention. So if the retrospective argument applies, that means you're facing additional tax, which is not necessarily a better animal. But be that as it may, the bottom line is we've been advised, and comparative law indicates that especially in tax laws, you often get retrospectivity, and there's no constitutional court judgment in this country that says that statutes in the civil context cannot apply retrospectively. And I think the judgments you refer to mostly, the criminal prohibition, which is evident, you can't criminally prosecute a taxpayer for an offence that didn't exist when you committed the offence. So yeah, that's also clear from the transitional provisions that a taxpayer post-TAA can only be penalised under previous criminal provisions. That's the legal view.
Okay, thanks, Katinka. So it's a policy view that the understatement penalty in terms of Section 222 can apply retrospectively.
Yes, I think that's the requirement that it's clear. I think in our view it is clear because although the conduct, the misrepresentation or the understatement was made in a return that was submitted before the understatement penalty regime, it's a question of when you impose the understatement after determining whether one of the applicable behavior categories are present.
Okay.
So that's the interpretive view at this stage, yes.
Okay. No, I appreciate you clarifying that. Thank you. Any other questions?
I've got a question for you, Chris. Obviously, the main focus has been on the question of retrospective application of understatement penalties, and that has certainly been the major immediate concern to taxpayers and tax practitioners out there. But what about other aspects and so on? And the one aspect that has crossed my mind is the question of prescription periods, which in certain instances were 3 years and have now been extended to 5 years under the Tax Administration Act. And I'll use something like, again, STC as an example. Have you any thoughts on that?
To be honest, Carl, it's not something I've considered. I don't know if anybody on the floor has a view. Yeah, I can't comment.
There's pre-existing rights here, Carl. I think the same argument of retrospectivity applies.
So, Perika, won't you just repeat that for the benefit of the audience with the mic?
We focused on understatement penalties in the discussion, but I think the same principles of retrospectivity applied to prescription. You had particular rules in place in 79, which related, say, to a 2007 year of assessment. I think there's a sound legal argument and basis on which to argue that those old rules would still apply. You cannot take away a right that existed.
Yeah. Look, an interesting one there that was actually a live example was a request that went in for a reduced assessment just prior to the Tax Administration Act being introduced, where at 30 September the 3-year prescription period would have ended, and the request was put in before that period ended, but it was still being dealt with. So SARS hadn't come back on an answer. And then after the implementation of the Tax Administration Act, my understanding is that SARS came back and said in terms of the new date of assessment, which is now for an income tax return essentially moved a month back, that period prescribed, and you've missed your chance to put in a request for reduced assessment. So, I guess in that case, the argument would be retrospective application. Your rights have certainly been, depending on the impact to the taxpayer, materially and adversely affected, and you'd have some kind of recourse, or you should, in that instance.
There's just one problem. The old assessment that have issued date, the new prescription notes were issued date, old date, new date. So they have a problem. Because the old assessments didn't have issue dates. They had a due date.
They had 3 dates. So there was a date of issue, a first date and a second date, and your date of assessment was on the first.
But remember, the new definition says prescription runs from issue date. So they have to put the issue date on it. There was never a date that says issue date on the assessment. And it's one of the requirements to have a proper assessment is the issue date, so you don't have an issue date.
My understanding is there's always been 3 dates on those assessments.
Yes. But go and look at the,
I agree what you're saying is right in terms of the Tax Administration Act, okay? But I'm not sure that you're correct in saying that that date of issue was not on the old assessments. My understanding is there were always 3 dates on those assessments. So issue, first date, second date.
Okay, thanks, ladies and gentlemen. I think we are out of time for this presentation, but if there are any further questions, I'm sure Chris will be around after the next speaker has spoken, and we'll be quite happy to chat to you.